we're going to be discussing her. So she filed a lawsuit to be released from
Yes.
her label, and the label is MK Entertainment. And so she's suing MK Entertainment, and who is actually owned, I thought this was interesting, is owned by her longtime manager, Jeff Robinson. And she is asking for the rights to her catalog. That's a different issue.
Right.
But the
Right.
core piece here is that she, signed in 2011 when she was 14.
14. Like, and that's crazy. I mean, just to be like just attached to somebody at such a young age. And I guess that kind of goes into your whole conversation about, when you're firing your management and stuff like that. And you even brought up Selena, I heard earlier, and you know how much love I have for Selena and her whole situation. And just when you're managed from such a young age, that's just got like starting from there. And then when you become an adult and you actually realize what's going on as you get older, your wisdom grows really fast in the industry. And so, yeah.
Yeah, so according to, and this is all happening in California. So according to the California Labor Code 2855, um, you know, uh, employment contracts, which is what her has with the record label, employment contracts can only go for up to 7 years. And then the employee has the right to terminate. There's a caveat, and this is where I think the record label is going to make their argument. But let's talk about her's claim first.
This
So
is in
she's
California,
saying,
you said specifically, right?
yes, specifically in
Right.
California, pursuant to California labor law, and so she's claiming if I was signed in 2011, then pursuant to the term of the contract, because there's stuff in these contract guys when it comes to record label agreements where the contract term starts after the commercial release of like the first album, so it's not necessarily when they signed in 2011, but she's
Mm.
arguing that the termination would be in 2019. So she's like 7 years from when the employment officially started is a
Right.
date in 2019. So here we are in
Is that where the
2022.
is that where I mean, obviously it's a separate issue for her catalog, but that's where she's putting the cutoff for her catalog after that point, then I'm assuming.
Yeah, so she's asking that the court make the contract voidable after that 2019 date. And to say that, not only is it voidable, so I would assume, of course, that includes any catalog after that date, but also it's called disgorgement of profits. So she goes, hey, label, for all the money that you made illegally, I want all that money paid to me. So we're talking about, roughly 2.5, 3 years.
Mm.
So, but she's obviously a huge artist too. I was
Oh,
looking at her
she's
plays. She got
incredible.
a cool 11 million listeners, monthly listeners on Spotify right now.
No, she's not only an incredible singer, her music is all vibe. It's that, it's that slow R&B vibe that I'm just in love with, that whole like neo soul kind of sound. And she's just and she's a really good guitar player too. Like, I have footage here of her. um she's singing. uh this is from 2018, but I have it later on. Like, I think she is this one. Oh, I might have grabbed the wrong clip. But I have a clip. I had a clip of her where she is just like shredding on the guitar. This is from the 2022. I'll find that clip. But she's really good. Like, she's a really good like player, and I
So
really like her music a lot.
David is a good question, right? So we said she signed the contract when she was 14. Are you able to enter into a contract as a minor? All right. So again, this is pursuant to California law. But, for example, in New York and California, there are laws in place to make it very difficult for minors to void a contract when they become of age. And that's because, of course, we have kids who are actors, we have kids who are musicians, and we don't want to create a lot of scenarios where these contracts are being found unenforceable. So that's, the minor's right to work kind of thing. But there are jurisdictions where the courts require that even other, they'll say in their state, us as a court, we have to approve the contract before we're going to actually enforce it. Not quite as harsh in California, but you do need to have obviously a guardian, a parent sign, right? We're going to have a whole lot of
Right.
issue if it's a 14-year-old signing a contract without a parent because you have what's called capacity issues.
Well, and
But
then
that's
all
a great
those,
question.
and then just is, because she is so long. So they have the regular labor laws. Is this also applying to like child labor laws? Because I know specifically they're really intense, and especially in the because California is a big entertainment industry hub,
Yep,
and for
exactly.
actors and stuff like that. I would just think that, it's a pretty interesting. I just wanted to show this just to say I wasn't fooling you. I mean, she is just like, I really wish I could play audio on some of these streams, but I don't want to get demonetized. But like, and then she just throws off the guitar and just starts singing. Like, she's so good. Uh, I'm a fan. So
Yeah, don't you
I hope
don't get us a strike.
yeah, I'm rooting for her. I'm rooting for her.
Well, yeah,
I
so
would
but
like.
let me go back. You were just kinda going into this. So,
Oh yeah.
in most states, individuals can void contracts when they become of age, right? So there is this ability for a minor when they become 18-year-old. They have a certain period, depending on the state and the state statute. They have a period to terminate the contract and void it. But
Mm,
again, because we know that New York, California, these are states where we want to make sure that entertainers are protected, entertainment companies are protected, that we want to hire kids. Because if that's the case, and all these kids are just voiding contracts, then why would they want to hire minors? But obviously you have to have consent, you have to have all kinds of things. So that was a really good question.
yeah, no, I mean, I think it's always tricky business when you're working with minors. I know that it's all kinds of special considerations have to be taken into account. I know that when we have shot music videos, we had an inevitable video, and we had a minor on the set that was actually in the video,
And
and we
Angels in the Valley, we had two minors
Oh,
on set for
Angels in
that.
the Valley. So, just making sure that, the parents are there, everybody knows what's going on, the proper, that they're taken care of first and all their stuff. So you're not holding them up and making them wait, and just really having special considerations and no shenanigans around any, minors.
Yeah, so as of now, I've not read that she is seeking to void the contract based on a capacity issue to say, I signed this, my parents were there. So because she's not making that argument by
Mm.
like negative inference, we can say obviously that there probably was a parent. But
She's
two
just saying
things
time
here.
limit. Is she just saying the
Yeah,
time limit? Yeah.
the
Okay.
California that exactly, exactly. So Brian has a good question here. He goes, what will be the issue if the label has not recouped if they gave her advances, right? So in standard record label agreements, the record label gives advances, whether those are marketing funds, your studio recording funds, and then what comes back from the music goes to repay the label first before anyone gets paid, right? Before her is going to get paid. And so often in these record label agreements, what happens is that it will say that the agreement will automatically continue extending until they've recouped. So that goes back again to the timeline and how the language was drafted. Because if it just says the contract keeps extending, that's one thing. If it says they're going to continue collecting revenues from the artist's career until they recoup, that's a different kind of more
Right.
creative way for them to, even if the contract is found void after 2019. So that's number one. Number two, let's actually take a look at the state statute, and I'm gonna and let's see if this would be the basis for the record label to say no,
No.
the argument is invalid. So here we go. Let me highlight this. I know it's a
Nice.
little small.
Yeah, I love that. I love it when you pull
All
up
right,
on the
so
screen.
so the first part of the statute, this is where it talks about so any contract otherwise valid to perform or render services of a special, unique, unusual, extraordinary, or intellectual character which gives its peculiar value and the loss of which cannot be reasonably or adequately compensated in damages and an action at law may none or nevertheless be enforced against the person contracting to render the services for a term not to exceed 7 years from
I
the
mean,
commencement of services. Okay, so that's her argument.
being a lawyer like should be an Olympic sport. Like, as you're reading these phrases, and I know that you understand what all of them mean, you're just like doing backflips and cartwheels and somersaults. Like,
I'm here to explain it. So then the last piece right here, if the employee voluntarily continues to serve under that contract beyond the time, the contract may be referred to as affording a presumptive measure of the compensation. All right. So basically, the record label, I believe, will come back and argue that she voluntarily decided to stay in the contract, and she did that because
mm,
she kept producing music, she kept doing different projects with them, and so they'll say you voluntarily did this, you had a benefit because we worked our asses off and we promoted, and look at you and your 11 million plays per month on Spotify.
what do you think about that?
I think that's obviously the argument that they're going to make. I think
Or
I think that
what do you think about that argument? The now that you're an adult, kind of thing. I don't know. Like, I don't know.
Her
But
her Go ahead.
you know, if the law, I would just, but I would imagine none of that really matters. If the law is written that that's the time and that's when it's done, then that's when it's done. Like,
Right.
right? Like I'm always looking for that. I'm always looking for that language. What you say, or you know, in these articles and stuff that just kind of seals the deal. That just kind of just like, well, that's it. Like if that's the law, then that's the law, isn't it? Like, why are we having all these conversations? Like, you could say
Yeah,
they
and
disregarded
so
the
where
law.
the attorneys are gonna get into the weeds is, did she need to know about it, right? So oftentimes when people are like, I didn't know that there was a 7 year and then I could get out of it, right? So most of the time that doesn't fly. I didn't know that speeding was,
Oh my
illegal.
god.
There but it's not applicable to everything. Sometimes there is notice and there might be, a required notice that the employer is supposed to send. There's other stuff, but this is where you get into the weeds if you're litigating these cases.